All right, let's get another perspective from these issues now. I'm being joined on the news at 10 by Professor of International Law and Jurisprudence, Professor Akin Oyebode. Thanks a lot for joining us on the news at 10, Professor.
You're most welcome.
To try or not to try, I think that's the way they say it in literature. So many of your learned colleagues have weighed in on this issue, what should have happened, and there have been various interpretations. How grave is this, do you think, for the judiciary?
Well, it's a trial that has consequences for the judiciary. I'm reminded here of the statement by Juvenal in ancient Rome, quis custodet ipso custodies, who will guard the guards themselves. Now the courts or the judiciary, the judges, are the sentinels of the liberties and rights of ordinary citizens, but that does not imply that they are above the law. One of the most respected judges in England, Lord Denning, in the celebrated case of Gurrier and Union of Postal Workers, opined, citing Thomas Fuller, "Be you ever so high, yet the law is above you." So judges are not immune, but then the prosecutor must ensure strict compliance with due process.
And that was where I'm going, because I'm not going to quote section 292 because it's out there and it's been quoted severally in the last couple of days. But people are screaming due process, especially lawyers. In your opinion, did the CCB err by not bringing him before the NJC first and doing it this manner?
Well, I think the prosecution ought to have followed the extant law in the country, that when an allegation involves a sitting judicial officer, then the matter should be remitted to the National Judicial Council. And if the NJC finds prima facie evidence of malfeasance or misconduct, then of course such a judge should be removed from the judiciary, so that you don't do an overkill, in my view. Since that was not done, it's a problem, but a problem that is not without solution. So the needful could be done for the matter to be properly brought before the Code of Conduct Tribunal. But I hasten to say that trying judges it's not a novelty peculiar to Nigeria. The Kenyan Deputy Chief Justice is being arraigned for corruption, tax evasion, and what have you. And in the recent past, judges not too far from here in Ghana had been removed from the judiciary on allegations of corrupt practices. So what is happening really is not unprecedented. The only thing that makes it remarkable is that we are dealing with the Chief Justice of the Federation, the highest judicial officer in the land. So I will respectfully submit that the Chief Justice should not listen to those who are saying disobey. It's not the practice of lawyers to disobey. And the Chief Justice is a lawyer first and foremost. That is why you find a whole crowd of senior advocates and lesser placed lawyers who decided to announce their appearance to defend the Chief Justice of Nigeria.
You think they shouldn't have gone in such a number? Or?
Well, again, you can't stop people from exercising interest in such a matter. Because lawyers tend to see courts as their marketplace. And they will imagine that any disparaging of the judicial officers, as we had last year, not to talk of the Chief Justice of Nigeria himself, could be a disservice to the entire legal profession.
Okay, Prof, the way you see it, can the CJN carry on, overseeing the affairs of the judiciary, even looking at perhaps his more immediate task of if any party decides to go to the Election Petitions Tribunal, with the way it is, whether he is in court or he isn't in court, what do you suggest?
Well, you know, you can't bring a judicial officer who has not been separated from the judiciary before another forum, before another court. I think wisdom would suggest that the Chief Justice of Nigeria should disqualify himself from further participation in legal processes. Well, he cannot remove himself except he resigns. The procedure for removal of the CJ is well known in terms of the Senate advising the president. So once we did not comply strictly with the extant law, then that gives ground for suspecting that maybe there's a hidden agenda.
On that note, I was going to ask whether all the talk about is this political, the timing is suspicious, quickly now, what you think about that on this talk of agenda?
Well, I would say all of the above, because it's a precarious situation and perilous circumstances that we are living through in the country. In another couple of weeks, we're going to have the presidential elections. And of course, ultimately, if there are any disputes, the matter will end up in the Supreme Court. So it's very difficult to separate politics from what is going on. But then, if you ask me, I would say that Honorable Justice Onnoghen had almost admitted violation because it's not been arraigned. It's not asked to make a plea. But my information is that he pleaded or said that it was out of inadvertence. Now, as far as I know, amnesia or loss of memory is not a ground, you know, for quashing any proceedings.
All right, Prof, on that note, I'm going to have to leave it. Professor of International Law, Professor Akin Oyebode, thanks for sharing your thoughts and breaking down that for us on the news at 10 tonight.